Yes, Mr. Ness.
Thank you, Your Honour. Mr. Gleeson is giving evidence this morning.
Will you take an oath on the Bible?
I'll take an oath, Your Honour.
There should be a Bible there. If you would stand for me and repeat after me. I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give in this Royal Commission.
That the evidence I shall give in this Royal Commission.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Yes, thank you. Take a seat, please. Yes, Mr. Ness.
Thank you, Your Honour. Would you tell the Royal Commission your full name and occupation?
Certainly. My full name is Jeffrey John Gleeson, and my occupation is I'm a barrister at the Victorian Bar.
Thank you. Now, Mr. Gleeson, you've provided a statement to assist the Royal Commission.
Yes.
Are the contents of that statement true and correct?
Yes, they are.
I tender that statement.
Mr. Gleeson's statement will become Exhibit 16-12.
Now, Mr. Gleeson, you were admitted to practice as a barrister and solicitor in 1989.
Correct.
And in 1992 you signed the bar roll.
Yes.
Which effectively meant you practiced solely as a barrister from that time on.
That's right.
And then in 2007 you were appointed senior counsel.
That's right.
Which is now called QC in Victoria.
For me it is.
Now, very early on in the life of the Melbourne response, you were engaged as counsel assisting to the Independent Commissioner, Mr. Callaghan.
Yes, I was.
And from time to time you did some ad hoc work as a commissioner when Mr. Callaghan, for one reason or another, couldn't.
Yes.
And then in August of 2012, you were appointed as an independent commissioner.
Yes, I was.
And from that time, you and Mr. Callaghan have effectively shared the burden of complaints that have come in.
That's right.
Has there been any process whereby one or the other of you do a particular type of work?
No, it's rotated really just on an alternate basis or according to work commitments. If perhaps I'm interstate and I would have otherwise taken a rotation, then Mr. O'Callaghan would take that matter. So it's just a practical way forward, really.
Since August 2012, how much of your time has been taken up as independent commissioner?
In terms of a proportion of my working day?
Yes.
On average, it would be perhaps 1 to 2 days of my week.
Mm. And you operate on a basis of a retainer with the Archdiocese?
Yes, I do.
So you don't charge per complaint, per day or per hour?
That's right.
And
I should say that I did. I moved on to the retainer basis when I became independent commissioner. I had, as counsel assisting, I charged on a hourly basis.
When you were counsel assisting, what proportion of your working day was taken up with that work?
Oh, considerably less. There'd be periods of time when, for weeks on end, perhaps even some months on end, when I'd do no work as counsel assisting. But then there'd be situations where a contested hearing would occur, and much as if I was running a trial that might go for a few days, it would consume me in the lead up for a few days of preparation and then the hearing itself. So overall, though, averaging it, it would have been perhaps a day every couple of weeks.
I take it when you became independent commissioner, you ceased being counsel assisting?
Yes.
Now, paragraph 3 of your statement, you say that you've considered 16 complaints as an independent commissioner since 2012. Is that right?
Yes.
And you...
Well, there's been more since my statement, I must say, but that was correct as at the date of my statement.
So your statement was dated on the 12th of August. How many more have you had since the 12th of August?
2.
Dealing then with the 16 that you refer to in paragraph 3, you've determined not to uphold one complaint?
Yes.
And you've attached to your statement a redacted version of your determination in relation to that one complaint?
Yes.
And is it a fair summary to say in relation to that complaint you formed the view that there were mental health issues that meant that you couldn't uphold the complaint in respect of the complainant?
Well, that was one factor. I concluded that the complainant did suffer from mental health issues, but it was really the gross inconsistency in the complaints and the somewhat fantastical nature of what the complainant said in many respects that really provided no sound basis for upholding the complaint.
Now, you set out in your statement the process that you follow when you deal with complaints as an independent commissioner. Have you adopted the processes that had been adopted by Mr O'Callaghan?
Yes, very much so. I had the opportunity to see over a long period of time the approach that Mr O'Callaghan took to dealing with complaints and formed the view that it was a very good process. It obviously needed flexibility according to the different circumstances that arise, and it's such a human process, this issue of dealing with complaints of sexual abuse, that no protocol should be slavishly adhered to, and Peter never did. By and large, I've adopted a very similar process of meeting with the complainant, recording what they say, sending out letters, and then the investigation takes its path according to the particular circumstances that arise. But I've also adopted, in the one matter that I've had where there was the respondent was both alive and in ministry, I adopted a similar practice to that which Mr O'Callaghan had adopted for contested hearings.
Now, Mr Gleeson, I want to take you to a number of elements of the Melbourne response insofar as your role is concerned. The first is in relation to standard of proof. If I can turn firstly to paragraph 87J. And Your Honour and Commissioners, a bundle of documents have been put together from the material referred to in Mr Gleeson's statement but not part of the tender bundle. If I can hand those 3 volumes up. And there's copies for others as well. This is a selection of documents that indicate Mr Gleeson's approach to his work as independent commissioner.
Do you want me to mark them as an exhibit?
Yes, I do. Thank you, Your Honour.
They'll become exhibit 16-13.
Thank you. And perhaps if the witness could be provided with a copy of the bundle.
Thank you.
Now, the paragraph 87J in your statement, you refer in that paragraph to a case of that you've described as IC1.
Yes.
And you've set out various documents which you drafted as a result of that complaint.
Yes.
In 87J, you refer to your determination, and perhaps that's in the bundle, if that can be turned up. And it's on the screen. Now, if I can just turn to page 4 of that, paragraph 5, Mr Gleeson. The standard of proof that you considered appropriate for the determination of facts is Briginshaw?
Yes.
Now, I take it that the standard of proof that you adopted was the same regardless of whether it was a contested hearing?
Yes.
So the Briginshaw test you applied in each and every case?
Yes.
If we can then come to paragraph 91. In paragraph 91, you refer to the first meeting. And then, if the complaint appears to be valid, you generally form the view at this meeting that you'll uphold the complaint. Can you just talk us through how that works?
I'm sorry, I was with 91 in the determination. You mean the
No, 91 in the statement.
Yes, if at the first meeting the complaint appears to be valid and it's apparent that the respondent is deceased, then I will typically form a view, at least privately, that I'll uphold the complaint subject to satisfying myself that the respondent was at the parish or school at the time of the alleged or the allegations, and that the complainant attended the parish or school, for example. I know Mr O'Callaghan's referred to cases he's had where the respondent's been in prison. I expect that I would adopt a similar approach there, but I myself haven't had a complaint in a case where the respondent's been in prison.
So do you follow the same practice as Mr O'Callaghan, and on receiving a complaint, obtain the files of the accused from the Archdiocese?
Typically I do. I'm not sure I've done it in every case. There may have been occasions where I've had a respondent who I've previously, a deceased respondent who I've previously dealt with a complaint in respect of, and I don't call for the file again.
Is that because you've retained records from the previous complaint?
No, it's really because it's not necessary, because if I've previously obtained the file, I may have retained a record of parishes that the priest attended, so that would be sufficient for my purposes, and otherwise I would retain a memory of the fact that this was a person who had been a repeat offender.
And the fact that they had, as has been referred to in this Royal Commission form, was sufficient for you to be minded to uphold the complaint?
Yes, coupled with the plausibility of the person who sits in front of me.
Now, plausibility has been a test that's been applied in other commissions of inquiry charged with looking at child sexual abuse matters, redress and the like schemes. What do you think of that as a test to be applied before determining whether redress or compensation should be paid?
Well, it's a minimum requirement. I use the word in the general sense when I just used it then. Someone who presents as being genuine, there's no apparent inconsistencies in their story. They seem to be rational, not delusional. When they recount the abuse, they appear to be, this is typically the case, they appear to be reliving the moment.
So is it fair to say that, leaving aside contested hearings, you really need to be satisfied to a lesser extent than Briginshaw demands?
No, I'm always mindful of the fact that this is a grave allegation, and it's inherently unlikely that people sexually abuse children, and these are the things that Briginshaw tells us about. So I'm always mindful of the fact that I'm making a serious finding, but in circumstances where somebody presents as apparently genuine, they tell a consistent story, they appear to be plausible. Obviously, in circumstances where the respondent has form, there's very little hesitation in finding that this person, this particular complainant, was sadly yet another victim of that respondent. But I've had matters where the deceased respondent has no form at all.
But you've nevertheless upheld the complaint based on the credibility of the complainant and checking basic facts as to who was where, when.
Yes.
Gleeson, have you ever pondered on the fact that you find it easier to make a finding favourable to an applicant when there's form, as you put it, but yet the criminal law imposes all sorts of restrictions upon using evidence of other charges in a trial? I
have, Your Honour. I had cause to research and make submissions to Mr O'Callaghan when I was counsel assisting on similar fact evidence. And although I don't typically practice in the criminal jurisdiction, I became quite familiar with the restrictions and inhibitions on relying on similar fact evidence. And I do take that into account, but to use that phrase, strikingly similar, sadly, some of the cases I come up against are strikingly similar.
Just turning to contested hearings, you would understand that Mr O'Callaghan has given evidence that his experience was that if a legal representative appeared and he was asked by that person or their client to meet the costs of the legal representation, he would do so, but not otherwise. You understand that was his practice?
Yes.
What's your practice?
Similar. The one contested hearing that I was involved in as Independent Commissioner, or have been so far involved in, the complainant was not represented. The respondent was. That's IC1, and you'll probably have seen from the material that I've included in my statement and the attachments that counsel assisting was able to really present the case on behalf of the complainant, and the submissions that you might have seen that are attached to my statement are really submissions that strongly support the proposition that the complaint should be upheld. You'll also have seen in my statement that I was fortunate enough to receive an email from the complainant about a year after.
Well, can we just leave the complainant in that case to one side for the moment and deal with the question of funding of legal representation? Perhaps if I can draw your attention to paragraph 87D of your statement, if we can have that document on the screen. Now, that's a letter that your counsel assisting received from solicitors who were appearing for the priest in a contested hearing.
Yes.
And then if we can just scroll down that letter, there's reference there to that the priest will have made satisfactory arrangements for the payment of legal fees, and that the solicitors in this case tried to contact Mr Moore, who you understand to be similar to a business manager with the Archdiocese.
He is the business manager, yes.
And then apparently Mr Moore didn't respond, and so there was an approach made to your counsel assisting. Do you see that?
Yes.
And then if we turn to the second page, there's also reference to that the solicitors are of the view that the priest should be advised prior to deciding whether to participate, whether a complaint has been made to the police, or alternatively, does the church propose notifying the police? Now, is that a request that's being made of you on more than one occasion?
No.
If we can then turn to paragraph E in the document behind that. Your counsel assisting asked for your views on that letter, and you say to provide him with a copy of the transcript of the conference and to the fact that you have referred his request for funding to Mr Moore. Do you see that?
Yes.
So is that the process you followed? If someone asked you for funding, you sent it to the Archdiocese for them to make the decision?
Well, it's the only occasion on which it's occurred, and in that case, I think that my thinking at the time was that because the solicitor in question had indicated that he'd spoken with Mr Moore and that had been his line of communication, but that he'd been unable to secure a response in the time that he'd wanted a response, that I would refer the matter back to Mr Moore. And I think that's all I had to do with it.
So that's the only occasion you've had to deal with that?
Yes.
Going forward, what will your practice be in respect of funding for legal representation for contested hearings?
Similar to Mr O'Callaghan, the parties are entitled to have legal representation and to have that funded in the event that they want it, but that counsel assisting is available to assist them through the process if they don't want it.
Mm-hmm. So it's a matter for them to raise it, and if they don't raise it, you don't raise it?
No, quite the opposite. In the contested hearing that I've so far been Independent Commissioner for. I know that Mr Woods, Council Assisting, raised it, but and of course that happened very early after I was appointed Independent Commissioner. It was a complaint that came my way within a short number of weeks after being appointed. I can say that should a potentially contested matter arise again, it would be my practice to inform the parties that that's their right.
So that's a departure from Mr O'Callaghan's practice?
Well, I'm not entirely sure that it is. I think Mr O'Callaghan tended to raise the topic if the need arose. I certainly, as Council Assisting, became well acquainted with the complainant and the respondent very early on in the process, and we would typically have conversations about, do I need a lawyer? Should I get a lawyer? Because the conversation would typically start because I would need to explain this role of Council Assisting. As you probably know, Ms Fairness, people don't quite understand the role. And in the course of explaining to complainants and respondents that I'm not their lawyer, I'm there to assist the Commissioner, it would typically provoke a discussion about, do I need my own lawyer then? And I would then tend to say, you're absolutely entitled to, and if you want a lawyer, it'll be funded. If you don't want a lawyer, I can guarantee to you that all the evidence that I consider relevant will be put before the Commission.
You're speaking there of your dealings with a complainant?
Yes, I went back and looked at the statistics, and it was more common for a respondent to have legal representation than a complainant. So the more conventional dynamic at a contested hearing was therefore for me as Council Assisting to be, in order to give balance to the Commissioner, to be really putting forward the case for the complainant.
That's what you considered your role to be as Council Assisting?
It was one of my roles. Ultimately, my duty was to ensure that all relevant information was put before the Independent Commissioner. But in circumstances where a respondent was legally represented, and therefore the lawyers for the respondent would lead the priest or brother or nun through the evidence of the contested hearing, but the complainant wasn't represented, it was my view that in the interests of balance and fairness, the role of Council Assisting in those circumstances became more akin to one advocating in favour of the complaint. And as I said, the submissions that Mr Woods put in relation to IC1 in support of the complaint were typical of the sorts of submissions that I would have put before Mr O'Callaghan in those circumstances.
When you were appointed Independent Commissioner, were any restrictions put on the time you could spend on a complaint or the amount of money or fees that could be generated in relation to a complaint?
As Independent Commissioner, did you say? No, and I don't want you to think by seeking that clarification it was any different as Council Assisting. There was absolutely no inhibition put on the time I could spend as Council Assisting or can spend as Independent Commissioner. In terms of fees charged, I, as Council Assisting, would eventually get around to toting up hours and sending in a fee slip, and I'd do so by reference to the work I'd done without necessarily being referenced to particular matters, and my fees would be paid. Now, as you know, those fee slips went off to cause, and that was about the extent of my communication with my instructing solicitors. They didn't know what I was doing or how I was doing it.
You understand that the Royal Commission is charged with looking at the way in which justice for victims can be attained, and particularly looking at redress schemes. Now, you and Mr O'Callaghan have elected the contested hearing as a model for determining facts when there is a dispute. Equally, a model available and known to the legal system is doing it on the papers, as it were, similar to a paper committal. Now, you've referred to that in your statement. I take it that you, along with Mr O'Callaghan, rejected that as an appropriate model to determine facts.
Yeah, I've got a strong view about that. I think it would be if not impossible, very, very difficult to, in a case of a contested complaint of pedophilia, to make a finding to the Briginshaw standard that a person had engaged in pedophilic activity by reading some papers. I can't conceive of that being a fair or just approach.
You understand that a number of redress schemes that have gone before, including in Western Australia, have done just that very thing, considered effectively on the basis of information provided by the complainant, whether they're satisfied to whatever standard they adopt in order to provide a payment of whatever the limit is. But you'd reject that as not sufficiently rigorous, would you?
I would, and I heard the reference made earlier this week during somebody's evidence to the inquisitorial model, and I similarly reject that as a fair and effective method of making a factual investigation. I think one of the great difficulties with effectively an inquisitorial approach, as distinct from a pseudo-adversarial approach that we take with the contested hearings, is as an inquisitor, one's required to test the story of the complainant and the respondent. And I think there's great difficulty in expressing scepticism as a fact finder to say to a complainant, to a victim, well, why didn't you complain to somebody? Why didn't you speak up earlier? Why didn't you? The sorts of questions that perhaps might arise. To fall from the lips of the fact finder, I think, would be very confronting for a victim. One of the advantages of the contested hearing is that once it becomes apparent that there's a factual contest, as Independent Commissioner Mr O'Callaghan and now myself in the one that I've done, very much take a back seat and sit and listen to the evidence play out. And I think that probably is more inclined to give the complainant the impression that there's no, that there's an open mind and there's no scepticism being expressed from the fact finder.
Mr Gleeson, you appreciate, of course, there'd be many countries who would debate with you the inquisitorial system, but we'll leave that to one side.
Yes.
But is the approach you take, and accept as appropriate, driven by a concern in relation to the finding in respect of the priest or religious, or is it driven by concern as to the consequences of the finding for the complainant?
It's both.
Do you understand what I'm asking?
Yes, I do.
You see, a redress scheme in itself has no consequences for the alleged abuser.
I'm not sure I accept that. We shouldn't underestimate
What we do is find whether, as the state schemes tend to do, whether the person's entitled to redress.
Yes, but a necessary step along that path is to determine that a person has engaged in pedophilic activity.
A person, yeah.
Yes, and unless there was to be no concern paid to the identity of that person, then that person suffers the appropriate stigma of having been determined to have been a pedophile. And I think it's probably a difficult, if not artificial, scheme to move through to redress against an unnamed or unidentified respondent, which you would need to do if you were not going to attach that stigma to the respondent against whom the complaint's made. And the other important point in terms of the identity of the respondent is that the complainants, I would say, if not always, almost always, complainants have said to me, it's not about the money, and I believe them. I don't think it is about the money. It's about being believed that that person, that priest, that brother, that nun, abused them. And I can't see it giving the degree of satisfaction to victims that they deserve to receive a finding that Father X abused them, I don't think it would be enough for them. I don't want to pretend to speak for victims, but my sense from having spoken to so many of them over the years is that they need to know that there's been a factual finding that Father X did that.
I rather expected you would say to me that there are real consequences from the work you're doing for the priest or religious, because the sense I have at the moment of the role of the independent commissioner is that it does, or your decision does have, or can have, disciplinary consequences for the priest. Is that right?
Absolutely. I hope I didn't communicate the contrary.
In other words, the process is not just about redress. In fact, it is as much about should the church discipline the priest or religious.
Should they discipline them? Yes. Should they take all steps they can to ensure that they don't offend again is the primary factor.
That's part of the process, yeah.
Yes. No, I'm sorry, Your Honour. What I was trying to communicate was that I think the system that Mr O'Callaghan implemented and that I've adopted, whereby there is a pseudo-adversarial approach to a contested complaint, achieves the matters that I've mentioned, a sense of satisfaction for victims, compensation and identification of the offender, steps taken to ensure the offender isn't placed in a position where they can readily offend again, and discipline of that offender.
Now, is a complainant cross-examined by counsel for
Yes.
the priest? And you know how the criminal law, at least in some states, has been careful to define the trial processes and the capacity for a victim to have to face-to-face confront an alleged abuser. Are you mindful of those issues and how they've been dealt with by criminal law?
Acutely mindful.
How do you address them then?
In a range of ways. As counsel assisting in the 16 or so contested hearings that I was involved in as counsel assisting, it's an important conversation you have with the complainant, and you talk about how do you feel about it? Do you want to do it? Can you be in the same room? If they indicate apprehension about being in the same room as the person, on more than one occasion I've arranged for facilities so that there's a separate room and they can participate in the hearing by video link. And that's worked quite successfully. But even being offered that opportunity, most complainants say, no, I want to sit in that room. I want to be there and I want to eyeball that person. I want them to know that I'm the adult now and I've got the power.
You'd accept that some victims might also take into account, in considering what sort of system they wanted, the amount of money that was going into the administration of the system, as well as the amount that was available to compensate them.
No one's raised it with me, but I can understand that that's a valid consideration.
And in determining the parameters of a redress scheme, I suggest you would rarely, when starting from scratch, design a scheme where it costs as much to administer as you are likely to pay out.
I think that's a fair proposition to say for this, that it again focuses on the money, and the redress scheme, and being called a redress scheme, it has a considerable focus on money, but the money spent administering a scheme to deal with complaints about child sex abuse are about more than the money. So it's, at one level, it's a valid comparison. How much do you spend to administer versus how much you pay out in compensation? But you're administering more than the doling out of money. You're administering the emergence of truth, the empowerment of victims who get the opportunity to speak up and to be heard and to be believed. And I think that's money well spent.
Now,
have you ever had any children or adolescents as complainants in contested hearings?
No. Typically, they're men or women about my age or a bit older. I'm not sure that there's been even any in their 20s that I've dealt with. I could be wrong about that, but they're typically 30, 40, 50 years and above.
Do you think you'd follow the same pattern if it was a child?
Oh, no. If a child, a complaint came to me in respect of a child, obviously enough, Rule 2.9 of my terms and conditions sets out the minimum requirement, and that is to not deal with the child other than with the written consent of the parents and to urge them to be present. And then I'd move from there to a consideration of what was appropriate in the circumstances, and I'd be very much guided by the parent or guardian. I wouldn't want to trample over the wishes of the parent or guardian. If I would suggest that there should be a child psychologist engaged to assist, but if the parent or guardian said, no, I disagree, I expect that I would respect the wishes of the parent or guardian.
If you were to engage a child psychologist for the purpose of taking the child's story or in some way being involved, would you feel obliged to seek the Archdiocese's consent for that expense before incurring it?
No. I must say I was slightly surprised at first and then remained impressed with the way that Mr O'Callaghan, as Independent Commissioner, just wrote the cheque. If he thought that money had to be spent, he'd write the cheque and he'd add it to his fee, and I've adopted a similar approach.
Now, just while we've got this document on the screen, if we can just turn to the previous document, there was a request by the solicitor there for information about whether or not the matter had gone to the police. Remember that? That's the
yes, I do remember that. Yes,
of your statement.
Yep.
How did you respond to that?
I can't remember. It seems from my email back to Mr Woods that I haven't.
Well, that was from, I'm sorry, paragraph 87D. If we can have that on the screen. If we can scroll down to the second page. It's that last paragraph I'm referring to, Mr Gleeson.
Yes.
What do you now recall?
Not much, I'm afraid. I expect it was probably ignored.
Now, that suggests that the priest on that occasion was of the view by his solicitors that it was his choice whether to participate or not in the contested hearing. That's right.
It does suggest that.
Have you, as counsel assisting, been involved in circumstances where Mr O'Callaghan, as Independent Commissioner, has used his powers under canon law as delegated to him to compel the attendance of a priest?
Not that I can recall. I don't recall, apart from one instance that I think Mr O'Callaghan adverted to in his evidence, I don't recall any non-compliance by respondents. There was one instance where there was a non-attendance, and I think Mr O'Callaghan gave evidence, and it is my recollection that the contested hearing was adjourned in case there'd been some misunderstanding as to the time. Another opportunity was offered, and again there was non-attendance, and then Mr O'Callaghan proceeded to make the determination. That's the only occasion that I recall there being any non-compliance.
Just turning now to your dealings with the police, and perhaps if we can have tab 52 up on the screen. Now, this is one of your file notes, Mr Gleeson, in relation to a meeting that you and Mr O'Callaghan had with representatives of the police.
Yes.
Now, and that was on the 12th of September 2012. You're familiar with this document, I take it?
Yes.
If we can turn to the second page, And down to the third dot point. Now, if we can just stop there. Do you see that paragraph that's on the screen?
Yes.
The I in that, is that you or Mr O'Callaghan?
This is my file note, so the I is me.
Now, you refer in that first sentence to the issue of reporting to the police, identifying the police without disclosing the identity of the complainant. Do you see that?
Yes.
Now, as at September 2012, that was not something that you did, as I think you had probably just been appointed, or you understood Mr O'Callaghan did.
Correct.
And you understood that the Towards Healing protocol, as it applied certainly in New South Wales, did that very thing in relation to reporting to police.
That was my understanding.
Now, you then set out your view that there was little the police could do with it, and a police officer said he tended to agree with that. Do you see that?
Yes.
So was that the end of that issue, insofar as you and the police were concerned, that you would not report the identity of the priest and not report the identity of the complainant?
Oh, not really. It wasn't the case that at the end of this meeting there was a clear resolution whereby Mr O'Callaghan and I had put a position that was accepted by the police. I think a better characterisation is to say we indicated what we thought the difficulties with the process were. At least one of the police officers was sympathetic to those difficulties. The other police officer, not so sympathetic. He was more inclined to say, well, just tell us and we'll sort it out.
Well, let's just scroll down to the next page. And you see there that the second police officer's approach was described as somewhat more robust, and he put the example of the church becoming aware of multiple serious allegations of sexual abuse against a priest, and unless the Victorian police were informed, it may be that the person continued to offend. Do you see that?
Yes.
So where did it end up after this meeting between you and the police?
Well, I emailed Detective Inspector Binion that day just to say, thanks for the meeting, let's keep the lines of communication open. I then, shortly after this, IC1, the complaint in respect of IC1 emerged, and it was an unusual scenario because on the front page of one of the newspapers it was reported that the priest in question had been put on administrative leave. I think that emerged because the Archdiocese appropriately informed the parishioners of the fact. Now, in those circumstances, and given the discussion we'd had, I thought it appropriate to revert to the police and to Paul Binion in particular and to say, well, I know that you know that the identity of the priest in question. Can I tell you that I've repeatedly encouraged the complainant to make a police complaint? He doesn't want to, but I'll keep encouraging him and I'll let you know if anything changes, and could you let me know and keep me updated from your end? I didn't get a response to that email either.
Let me just stop you there in terms of the chronology. Are you saying that after this meeting in September, the next event that occurred with you as Independent Commissioner was in relation to IC1 that was relevant to your dealings with the police?
That's my recollection.
So perhaps if we can go to paragraph 39B of your statement, and that's where you indicate that you met with a priest who telephoned you together with the complainant, and you recorded that meeting, and perhaps if we can have the document in B on the screen. And if we can turn to page 7, which is 005O of that document, and down to the last large paragraph, which is attributed to you, Mr. Gleeson. Now, this is what you're recorded as advising the complainant on that occasion. and that is you have the right to go to the police and you will continue to have that right, and you urge the complainant to do so if that's what they want. And then you go on to say you don't have to decide now, you can go today, tomorrow, next week, next month and forevermore. And that if you want to, what we recommend is that you do that first. Now, just stopping there.
Yes.
You recommended that you go to the police first.
Yes.
Why did you make that recommendation?
I'm very clear in my mind as to the importance of doing that for a number of reasons. I think that making a complaint to the police and having a paedophile brought to justice is paramount. Secondly, something that's not readily understood by complainants is that if they go through the commission process and tell their story, have a contested hearing where they're perhaps cross-examined and there's a full range of information provided by them during the course of the independent commission process, and then they go to the police afterwards, what can happen and has happened is that the lawyers for the accused priest subpoena our files.
Get hold of the documents, yes.
For the purpose of comparing and contrasting what the complainant said to the commission and what they may next be saying in the police complaint. And I think that's something that complainants need to understand, that they are potentially exposing themselves to that difficulty. And it's not a difficulty, of course, that would arise if the positions were reversed.
Do you give advice to complainants as to your opinion as to the prospects as to what police action will or will not be taken?
No.
Now, that's something that you understand Mr O'Callaghan certainly did on occasions.
Well, I understand the cross-examination of Mr O'Callaghan in relation to Mr Hurstbach.
No, let me stop you there. You understand from the cases of Mr Hurstbach and Mr AFA that there's transcripts of discussions whereby prospects were told to each of them. You understand that? I'm not asking you to comment on that part of the evidence. I'm just asking you to accept that the transcripts record that advice was given. Do you understand that?
Could you just re-put the question, please?
I said that that's... Perhaps if we can just scroll back the transcript. The question was, first of all, did you give advice to complainants as to your opinion as to the prospects as to what police action will or will not be taken? And you said you didn't. And I said that's something that you understand Mr O'Callaghan did on occasion. Now, you understood that on occasion he provided advice to complainants as to what he thought the police might do. You understand that?
I wouldn't characterise the two instances that I'm now aware of as constituting advice as to prospects.
Do you provide information to complainants as to what you think the police will or won't do with their complaint?
Only in this sense. If I say to a complainant, you have a continuing and unfettered right to go to the police and I urge you to exercise that right, in circumstances where it typically is the case, the offender is dead, the complainant will typically say to me, what's the point of me doing that? And if you want to call it advice, or the information I provide is to say, nonetheless, the Victorian Police have stated publicly that they would like complainants to make reports to the police in respect of dead offenders. And typically the complainant will say, I still don't understand the point. And I say, well, my limited understanding is that the police would record the complaint, they might take a brief statement from you, and my understanding is that it's probably a pretty quick process if you wanted to do that.
So that's providing information about the process?
Yes, it is.
Not the outcome of the police consideration of the complaint?
Well, if the offender's dead, there can be no outcome in terms of the offender.
In relation to that example, but looking at other cases where you've spoken to complainants about the police, I take it the offender has been alive?
Certainly in IC1 and perhaps one or two others.
Now, if we just continue down with this transcript with IC1, there's a further discussion, perhaps turning over to the next page, in relation to what they are considering in terms of going to the police, and then over to the page 9, which is the next page. If we can just stop there. The complainant says, so if I decide to go to the police, we'll just let you know. And you say, that's right, and I would then just wait. And you're telling them that they can come back whenever that police process is finished and
Yes.
start the process with you.
Yes.
Now, just the next entry, I take it that's the complainant speaking, and I'll get some advice from, now without telling us the name, can you tell us the position of the person that's referred to there?
Not without seeing the unredacted version, which I'm sure I can obtain pretty readily.
Right,
There was a priest who accompanied the complainant to this meeting, and the complainant greatly respected this supporting priest, and it could be that that this is a reference to the complainant talking about getting some advice from the supporting priest, but I'm not sure.
Now, if we can then turn to paragraph 46D, still in the matter of IC1, and this is an email that you wrote to the complainant on the 31st of August 2012. And if we can have that document. Now, just in terms of timing, how far is this after the interview?
I think the interview might have been about the 20th of August,
Yes.
perhaps.
So about 10 days or so prior. And you then indicate that if you want to refer the matter to the police, you urge them to do so, and you provide those details.
Yes.
Now, I understand that this is probably one of your first cases as Independent Commissioner. Did you understand it to be Mr O'Callaghan's practice to provide contact details?
Yes, and indeed to pick up the phone and call an appropriate police officer in the presence of the complainant. I think that's happened from time to time.
And these contact details, they're the details of the police officer that you spoke to in September. That's in relation to the file note I just took you to.
That's right. I think probably what had happened is that I'd made arrangements or had some contact with Detective Inspector Binion prior to the 31st of August, but we hadn't yet met. That was in another couple of weeks that we were to meet.
Yeah. Now, can I just turn to paragraph 50A of your statement? Now, this is in relation to IC2, but also in relation to the police. IC2 was a case that you heard this year.
Yes.
And you met with the complainant in March 2014, according to paragraph 50A of your statement.
Yes. When you say heard, it wasn't a contested matter, so there was no hearing, but I investigated the complaint.
Now, by the 11th of March 2014, the Victorian inquiry here had reported, had it not?
Oh, I can't remember, I'm sorry.
No. Were you influenced by the findings of the Victorian inquiry at all in your dealings with the police?
In what sense?
In any sense.
None that come to mind. Certainly there'd been the ventilation of issues in relation to the police. There was a submission made to the Victorian Parliamentary Inquiry by Assistant Commissioner Ashton that raised matters that seemed to me to fundamentally misunderstand the way that the Independent Commissioners operated. So I was influenced in the sense that I considered that. I considered and reviewed the way that the parliamentary inquiry dealt with that and didn't accept that evidence.
So in terms of the findings, not the process or the evidence, but the findings of the parliamentary inquiry.
Well, you'd have to refer me to a particular finding before I could give a more meaningful answer, I'm sorry.
Well, did you make any changes after the parliamentary inquiry report was published?
I don't think I've made any changes to the way I've approached dealing with the police from the time I started as a result of anything.
So coming back then to paragraph 50A, if we can have that transcript on the screen. So this is an interview you did in March this year.
Yes.
We can turn to the second page. And you see that starts about 3 lines down. You refer then to the allegations amount to criminal conduct, and you're of course entitled to make a complaint to the police, and we encourage you to do so. Now there you refer to whether the respondent is deceased. The Victoria Police, particularly in recent times, stress that they're still interested to hear from victims. Now you gave evidence about that a short time ago.
Yes.
When was it that you first referred to the Victoria Police's approach, particularly having regard to your reference to recent times there?
I couldn't be sure, but I'm reasonably confident that prior to when I was appointed Independent Commissioner in 2012, I had heard somehow from the Victorian Police that they were keen for complainants to make reports to them in respect of deceased offenders.
Right.
So I expect that in all cases when I've been Independent Commissioner, even when the offender is deceased, I've said words to the effect that I've said here.
Now, if we can just go to tab 55A of the bundle. Now, this is an email for you in May 2013, so that's just short of a year before the interview in March 2014. This is an email to you to the police officer, Binion, and he's the same police officer you met with in 2012, that's right?
Yes.
And the same police officer that you referred one of the complainants we've dealt with to?
Yes, he didn't take up that referral, but
I beg your pardon?
the complainant didn't take up the referral, but it was the name I gave to the complainant.
Yes. If we can just scroll up. And you're advising the police officer that you've concluded your investigation and recommended that the priest be removed from further public ministry, and that you'd repeatedly encouraged the complainant to report to the police and he didn't want to.
Yes.
And he signed a document to that effect.
Yes.
Now, tell me, why did you tell the police about the priest, the name of the priest and the nature of the complaint and the period in which it occurred, when the complainant didn't want to go to the police?
I didn't inform the police of the identity of the priest. As I said in my earlier evidence, it was on the front page of the newspaper. And I sent my first email to Detective Inspector Binion, referring to the fact that this is a complaint I'm dealing with. I'm sure you've seen it on the newspaper.
So the priest referred to here was the priest that was referred to in a newspaper article?
Correct.
And why did you send this email?
Because I'd met with Detective Inspector Binion. I thought it was important to keep the lines of communication open with the police. As I'd said to him, it was a matter about which the police were aware, and I'd emailed him to say, I know you must be aware of this because the priest's been named in the newspaper. And I thought, both as a professional courtesy and a matter of relevance to the police in the context of the discussions we'd had, I thought it appropriate to say, I've now concluded my investigation. and I've upheld the complaint.
Did you hear any more?
No. Well, not for a long time. I have to check the dates. Could I scroll up on that, please?
You can scroll up. May 2013.
I think I received a response in July 2013, perhaps.
Do you now recall whether the police investigated that priest?
Yes, as I say in my statement, what happened, and this perhaps has not been entirely clear because of the redactions, but it's this priest in respect of whom I subsequently, perhaps about a year later, received a communication from another police officer, Rebecca Gunther, and she informed me that, or requested from me my file. I said, of course, I'm happy to cooperate with the police, but I think it's appropriate that I inform the complainant that you've made this request. And she said, of course. I then informed the complainant and went back to the police officer. She asked me whether the complainant was resistant, and I said I wouldn't describe him as resistant or enthusiastic. I'd say he's resigned to the fact that you're going to get my file. I said that by way of email, and she almost immediately telephoned me, and I've got a file note of my conversation with her that's attached to my statement. And she said, in substance, unless he's enthusiastic, we won't issue a warrant for your file. We've got enough work to do dealing with people who are knocking on our door without pressuring people who don't know whether they want to speak to us.
Now, those representing you, Mr Gleeson, handed me a letter this morning from the Victoria Police Detective Inspector Juning to the Vicar General, and perhaps if we can provide copies of that letter to the Commissioners. Have you got a copy of that letter?
I have.
Perhaps if we can provide it to others.
Do you want me to mark it?
Yes, I'll tender it, Your Honour.
1614.
Now, how did this come to your hands, given that it's addressed to the Vicar General?
I received it by email, I think yesterday, from Mr Francis Moore.
Now, it's a letter to the Vicar General in reference to a meeting that was held between a police officer and the Vicar General in relation to what is described here as the perception that victims contacting police necessitated a full police investigation and judicial response. It goes on to say, as we indicated, that is the police, that is not the case. In line with that is the police ongoing reforms in responding to reports of adult sexual abuse, we recognise and acknowledge the victim's right to decide the course of action they wish to take. And then there's reference to fundamental to that decision-making is a sound understanding of the various options available. And the Vicar General had sought a paper or brochure outlining those options in order to presumably provide them to complainants. And this letter attaches one such brochure. And the last full paragraph, if we could just scroll up. The police say there that I would also like to reiterate that the information contained in this material is brief, and it is our view that victims should be afforded the opportunity to speak with a specialist police investigator to discuss the options fully and answer any queries that may arise. Now, I take it that you would agree with that sentiment, Mr Gleeson?
The entire sentiment in the letter, or the...
No, just that last one I referred you to.
They should be afforded the opportunity, certainly, yes.
And then turning over, there's reference to the Sarno task force. And on the side bar, if I can describe it that way, there's, if we can scroll down, please, so we have the top of down, the other way. So we have the top of the... It says it's your choice to make a formal police report and initiate an investigation, or tell your story and defer any decision to proceed, or make a statement with a clear decision not to proceed formally. Now, I understand that you've only received this recently. What's your present intention in respect of this brochure and dealing with complainants?
The brochure actually came about because the Archdiocese requested it, yes, and it's been some time coming. The reason for it being requested, and this is to answer your question, the reason for it being requested is because, for among other things, is the independent commissioners would like to be in a position at the first or as soon as possible when meeting with a complainant to provide them with a brochure from the Victorian Police to set out their options. I must say that I think my first impression is that it's a good document as far as it goes. It's likely that when providing it to the complainant, I'll add one other option for them in addition to the three, and that is not to go to the police. This, of course, and understandably being a police document, sets out three options, all of which require the complainant to go to the police. I'd very much like every complainant to go to the police, but it's not my choice. So I'll tell them that while I'll urge them to do it, if they don't want to, I'm not going to force them.
Just to be fair to this document, it doesn't actually require them, but it actually gives them the three options, each of which is going to the police.
Each of which requires them to go to the police, yeah.
Well, it doesn't require them, it gives them the options of going to the police.
Well, you can't make a formal police report or tell your story or make a statement unless you go to the police. So it's in that sense I was saying each of them requires them to go to the police.
It's just the word require I'm taking issue with, Mr Gleeson.
I understand that, and I think the way the document's drafted, the three choices that are presented, and the only three choices that are presented, require the complainant to go to the police.
Well, we'll just differ on that. Now, does this document satisfy, to the extent that you are of the view, as independent commissioner, understanding you're not the Melbourne Archdiocese which requested it, does this satisfy what you need to tell complainants, given what you've already said about telling them that they don't have to go to the police?
I don't think it satisfies it in the sense that I would still need to say the sorts of things to victims that I've been transcribed as having said in IC1 and IC2. I think it's important that they understand the consequences if they go to the police. It's certainly not the Independent Commission's intention to indicate that there'll be great delays on them receiving compensation if they go to the police, but I think they're entitled to know that if they go to the police, we will stop our investigation. So I'd certainly have to add that in.
But that's in relation to what you do. In relation to the police and what the police might do, is this sufficient for your purposes?
Certainly.
Yeah, thank you. Now, in the time that you have been Independent Commissioner, have you advised any complainant as to whether they should seek legal advice on the basis that you believe they may have some common law entitlement?
The answer to that is a partial yes. I've advised them of their right to seek legal advice, but I haven't adverted to the reason why they should do so. I think it would complicate and confuse people to start talking in the language of common law legal rights. So I just limit it to saying you can see a lawyer.
Do you invariably tell people that they can see a lawyer, or is it only in certain cases that you've said that?
It's not invariable. If a complainant comes to me and makes a plausible complaint about a deceased offender, and I form the view pretty quickly during that first meeting that I'll uphold the complaint, it's my practice not to start talking about lawyers. In terms of dealing with me, if I'm satisfied I'm about to uphold their complaint, if I was to say, now, you understand you can get legal representation.
Let me just stop you there. I was asking about legal advice rather than legal representation, so perhaps if we can just confine ourselves to legal advice rather than representation for the purposes of your proceedings.
I was intending to sort of capture legal advice by their legal representation when I was giving the answer, and I think in terms of the advice they would need from my part of the Melbourne response, the factual investigation and the determination, if I've already decided in my mind that I'm going to uphold the complaint, I don't see there's a role for legal advice in terms of the upholding of the complaint. Now, that's not speaking to the compensation panel issues, but for my part, I think it would be unhelpful to say to somebody, you should seek legal advice, when I know I'm about to uphold their complaint, because they'll inevitably say to me, what do I need a lawyer for?
So in what circumstances have you suggested to a complainant that they seek legal advice?
I don't think I use the phrase legal advice. I think I use the phrase legal representation.
And that was in relation to a contested hearing?
Typically, it would be in relation to a matter where I wasn't, at first blush, aware of the fact the offender was dead. Sometimes I don't know. Sometimes I sit down with the complainant and I don't even know who they're there to complain about. Quite often that's the case.
I'm just trying to understand, Mr Gleeson, whether when you raise legal representation, you are referring to representation as part of the Melbourne response or representation outside of the Melbourne response?
I don't distinguish between those two. I mean, I'm part of the Melbourne response, and so in the context of me being part of the Melbourne response, if I utter the words, you're entitled to legal representation, I suppose it could be interpreted as being...
What do you mean? Do you mean legal representation as part of their dealings with you as part of the Melbourne response, or do you mean, when you say it, legal representation separate from the Melbourne response?
Well, I don't see it as my role to tell people that they can get legal representation for other parts of their life. I'm talking about the reason that they're attending on me, which is part of the Melbourne response.
Do you form a view as to whether they have any prospects of taking civil action in respect of the complaint that they've made to you?
I haven't had occasion to.
Do you consider that part of your role?
No.
Now, can I just turn to paragraph 87 of your statement? And this is back to IC 1. Now, in 87, N, you indicate that you wrote to the complainant and informed him of your recommendation and his ongoing entitlement to receive counselling and the like. And then you, perhaps if we could have that on the screen. We have M on the screen. I'm not sure if it's part of the bundle, but we can have it on the screen. We'll just have it on the screen. If we can just scroll up. Now, if we can just stop there. This is your letter, having completed your part of the process, to the complainant. Is that right?
I think that's right.
That's how it reads, isn't it?
Yes.
And you've forwarded a recommendation that the father remain on administrative leave.
Yes.
So I take it that he had been put on administrative leave either prior to your involvement or at the beginning of your involvement.
No, I recommended to Archbishop Hart on, I think, the 30th or 31st of August that the priest be placed on administrative leave, and immediately received a written response saying that that would be effected immediately.
And so when you say remain on administrative leave, what were you seeking to convey to the Archbishop? That the
administrative leave that had been imposed upon the priest remain in place indefinitely.
Indefinitely?
Yes.
Would you expect to then hear back if the Archbishop received other information from which he was minded to lift that restriction?
Absolutely.
And that you consider part of the Melbourne response?
Well, if I remained as Independent Commissioner and I'd expressed myself in these terms, that the recommendation be that the priest remain on administrative leave, and there was a consideration of not adopting the recommendation on factual material, then I would expect to be informed. But in the end, I can only recommend.
Now, is this a standard type letter that you write, or do you tend to tailor it?
I've only done it once.
Oh, have you?
Well, there's only been one contested hearing.
But you've written after a determination, regardless of whether it's a contested hearing.
No, I've written on numerous occasions after a determination upholding the complaint, and no, there's not a standard form. There's certain content that has to remain fairly standard, but they're not easy letters to write, and I write all of them individually.
Perhaps if we can just scroll up. And that last paragraph, I wish you well in the future and would welcome the opportunity to have a chat with you about matters. Perfectly understand if you're not inclined to make contact, but if you do, please give me a call. Now, is that standard?
I couldn't say it's standard, but I'll typically say something like that. Sometimes I'll send the letter containing my determination under cover of an email, which I think is a little less formal, and I'll tend to say something to the effect that you have my great sympathy. I might try to talk about something that has come up during the course of our discussions, and I'll usually say something like, you know, my door's always open if you'd like to come and have a chat. Understand if you don't want to. So it's a way to try to elicit some feedback, but in this case, the complainant did come back, but in most cases they don't.
In most cases they don't?
Correct.
Perhaps if we can then turn to paragraph P of paragraph 87, and in this case, having written to the complainant in May 2013, a year later, in May 2014, you received an email. Perhaps if we can have that document on the screen. And this is from this is the complainant emailing you, Mr. Gleeson.
Yes, it is. Yes, in IC1.
Yes, and he says that he wanted to write to you about his experience, and he says the experience was positive and it worked for him, and he says he always believed that he would get a positive outcome because he knew he had told the truth and had no reason not to. He talks about the pain, guilt and anxiety which will probably never go away, but he was glad he took the step to do something, and that's why the independent commission was good for him. Perhaps we can scroll down further. He talks about his being extremely apprehensive because he hadn't done anything for 30 years and was unsure whether he'd done the right thing, but it was the best option for him, and he wouldn't have been able to go through a court case with a jury for many reasons. And then he speaks of the independent commission of being of great value because it gives an opportunity for victims to come forward in a private and respected way. And he expresses the view that the fact that the commission is set up by the Catholic Church is a good thing because every case is taken out of their hands and there's no influence on the outcome. And he said he was afforded the utmost respect and compassion from the contested hearing, and talks about how people were kind to him and his wife. If we can just scroll down further. And he then offers his assistance to you if anyone going through the process could do with having a chat to someone like himself, then he'd like to help. Now, have you taken him up on that?
I contacted him. I've contacted him a few times by email in response, and we've talked about the way we might do something like that. I think that with the parliamentary inquiry and then the Royal Commission, I think the substance of what I communicated was that there's a fair bit on our plate at the moment, and I'd really like to take up the opportunity in the future to do that.
Yes, it has some merit, doesn't it, that someone who's gone through the process speaks to others who have yet to go through it?
Oh, absolutely. I can talk all I like to victims about what the process is like and the benefits of it, but it would be just invaluable to have people who've been through the process, whether they've liked all of it or not liked all of it, to just talk to other complainants about their experience. Some complainants come with solicitors who have real exposure to the Melbourne process and they understand it pretty well, and I'm sure they inform them about the good and the bad of the system. But quite a lot come on their own, so it would help.
Now, since you've been Independent Commissioner, have you been involved in discussions with CareLink as to whether or not payments should or shouldn't be made to complainants whose complaint you have upheld?
Oh, only in the sense that I have referred a number of complainants to CareLink, sometimes during the process. One of them immediately after the first meeting, because he was so distraught, I immediately contacted CareLink and he was urgently seen by them, and others have been referred to CareLink after I've made my determination.
I understand you refer people to CareLink. My question was whether you'd had any discussions with CareLink as to whether or not payments should or shouldn't be made to complainants whose complaint you have upheld and who you have referred to CareLink.
No, I can't recall any discussions about particular parts of their payment or particular aspects of expenses that should or shouldn't be paid.
Now, you would have heard there was concerns raised by at least one and perhaps two of the people who've given evidence in this Royal Commission about their experience with the Independent Commission and the location of the interview being barristers' chambers. Now, have you given thought as to the appropriate place for you to interview complainants?
I have. I typically interview complainants in my chambers, which I wouldn't describe as quite so monstrously sized as Mr O'Callaghan's, but it's a reasonable sized room, and it looks for all the world like a barrister's office. I have thought carefully about the best place to meet with complainants, and I'm not convinced that it's a significant issue. I think these are really difficult meetings, and I'm sure that people feel apprehensive coming to see senior counsel, going into the city, going into a barrister's building, but within, I think, a few minutes of discussions, it all becomes about the human beings in the room. And I try during those early minutes to talk about the footy or talk about some small talk so that they're put at ease. My chambers aren't particularly barristerial in the sense that there's not many law books on the wall. There's photos of the kids, there's a painting of Peter Dacos on the wall. There's usually something to talk about other than legal matters. And I'm not convinced that something like a serviced office would be better. I think they're pretty sterile. It'd be quite inappropriate for me to go to the complainant's house. I think that's far too intimate and personal and not private. So if you take those other two alternatives out, you're probably left with something like an office. In the end, I sit at the table, they sit at the table. If we were to go to a different type of office, it'd be a table and a chair.
Does barristers' chambers in Victoria commonly have shared conference facilities?
No.
Now, just finally, in relation to record keeping, you've heard Mr O'Callaghan, he keeps paper files for each complainant.
Yes.
How do you keep your records?
Paper files.
For each complainant?
Yes.
Do you compile the material in any way, spreadsheet and the like, to enable you to have a ready reckoner as to what you've done and who are particularly the accused? Almost
since I commenced as Independent Commissioner, there's been preparation for the parliamentary inquiry and the Royal Commission, and so these sorts of schedules are available to me in various different forms by reference to complainant, an offender, date of offence, nature of offence, I can access it any number of different ways.
Thank you. I have nothing further, Your Honour.
Yes, we'll take the morning adjournment.